Hey everybody, welcome. It's me, JJ Panzer, your smart apartment advisor, back for another weekly client call and ready to dig into the latest legal information and the AB 3088 that was passed at the 11th hour on August 31st, the COVID tenant relief bill, and also the conflicting parts of the law with the Preston legislation. Today, we're just going to focus on all of this with Denise and talk a little bit about where the industry is and where we want to go as property owners and property managers with regard to all the tenants who have asked for and received deferrals from their rent. And how do we recover, all of us, and including the tenants, recover from the damage of this pandemic, and how do we move forward? So with that, I want to introduce Denise, our very special guest as always. Welcome, how are you?
Very well. How are you?
You know, glad to be able to breathe again, as I was saying earlier.
Yes.
So at least we have that. But tell me a little bit about the conflict between, I mean, maybe we should start with talking a little bit about the basic framework of AB 3088. It seems like a lot of the most important stuff has to do with, obviously the fact that evictions cannot take place for rent that's uncollectible related to COVID crisis, loss of income, and also that we will be able to collect in small claims. We talked a little bit about that on a previous call, but what do you think are the most important parts of it for the practice of owning and operating real estate going forward in the next year?
So to answer that last question, I think you just need to be very, very mindful of the very specific deadlines and restrictions and orders and law regarding the collection of rent due to COVID financial hardship, and the time that the outstanding rent or outstanding other additional payments, for example, capital improvement pass-throughs and late charges and things of that nature. If you are inclined to demand those on notices, you need to be very mindful of when those were obligated to be paid by the tenant, because there is a difference in the law, there's timing differences in the law. Essentially, from March through August of 2020, you may not evict for non-payment of rent during that period. You may seek reimbursement through a breach of contract action next year, starting in March. So that's a money damages. It's not an eviction for possession damage claim. It's monetary damage. But you must follow the very particular guidelines that have been imposed by the state of California, but with the underlying problem for us that we have the Preston legislation that is more restrictive than the state law, AB 3088. So what we're trying to do is come to some sort of, we're going to try to find out if, due to Preston's legislation being in direct conflict with state law, San Francisco County no longer has to follow the Preston legislation. We are seeking an order on that as soon as the next 6 days. So hopefully we will have some resolution there. It may not be resolved, in which case we need to take the forms that the California Association, Apartment Association, and other state agencies have provided to all 58 counties and customize it for San Francisco County to take into consideration the Preston legislation overlay. So that's what's currently being bandied about. But with respect to the timelines, we must get notices out to the tenants by no later than the end of September regarding what all the processes are. So to just really briefly go through it, from March 1st to August 31st, you cannot evict for non-payment of rent if it's COVID related.
Right.
Then September 1st through January 21st, January 31 of 2021, you may evict if rent was not paid in at least a 25% amount. And that's a whole nother process.
Right.
But the key to making sure we're doing the right thing for the next year as property owners, and for the next few months, I should say, for as long as 3088 is effective, is to follow very specifically the obligations of notice to the tenants, and then obtain information back and have a sort of parlay of information back and forth and back and forth. Because if a tenant provides a declaration confirming that they are unable to pay rent, that is good in court. And if you find out that they were misrepresenting that declaration, then they have no protection under 3088. So it's a whole process that we all have to become very familiar with. And there's so many nuances that we can't even fathom yet because we haven't started the process.
Right, right. And so, one of the things that has been streamlined or at least clarified is that, yes, a judgment for possession is no longer possible for those previous rent amounts, but it's possible to pursue money damages. Do you anticipate that anybody's going to have much success in collecting unpaid rent for March to August if they choose to go the small claims route to try to collect it? I mean, you'll get a judgment, but what's that judgment really worth, and how likely is it that the tenant, I mean, they may or may not have the resources to pay,
right?
But even if they do, it's going to be very difficult to enforce that, isn't it?
Well, it is, but a judgment is good automatically for 10 years,
Okay.
and it's automatically renewable. So at some point, depending upon the situation with the tenant, I mean, it's a business decision on the part of an owner. And the small claims for residential rent owed, jurisdictional limit of $10,000 has been lifted. So if you have a tenant who owes you $25,000, you can proceed to small claims court, which is a much, much faster process, obtain a judgment, and that judgment is good. One day they're going to rent a car, they're going to want to buy a car, they're going to want to purchase a property, purchase a business. That judgment is going to show up if they ever want to get credit of any significant amount. And either you will have the full amount paid if you receive a judgment,
Okay.
or you will negotiate something to get some money from your judgment in order to get it done. So I think it's definitely worth it. The problem will be is if somebody gets a judgment and then they leave the state. That's more difficult to obtain a judgment for, but you can also have a judgment that is recognized in other venues. So
Okay.
It's really dependent upon the situation.
But if they leave the state before you file your suit, you can't really serve.
You can serve. You're going to be out of state. It's more expensive, sure.
Expensive to do it, but you can still effectuate service and compel them to return to San Francisco for the trial, for the small claims court proceeding, correct?
Yes, if you so desire, but if they don't show up, they would be defaulted. So
Right.
You win. So
that's good too.
yes.
Well, it'll be interesting to see how many people actually go that direction. I mean, I hope that mostly what this serves to do is motivate people to negotiate something.
Right.
Do you think it's more advantageous in that circumstance to file first and negotiate after you get the judgment? Or it seems like you probably want to try to negotiate, a payment plan and then sue if the payments don't get made on time?
Yes. You can approach it all many different ways. If you have an outstanding debt of $15,000, are you willing to take $7,500 and be done with it? I mean, that's a whole different conversation. That's for the amount of money that's owed. However, if you have a tenant in possession and they owe that money through August 31st of this year, and they're still in possession, then it also kicks in that you can terminate should they continue to fail to make the payments. And they are now required to make the payments of at least a minimum of 25% of their rent
Right.
through the end of January 2021, assuming you've provided the notice, you've provided the documentation the form that they need to fill out in order to confirm their financial status.
Right.
Have them send back the declaration. You have a chance to review it and vet it and call these folks. They're saying that they're not working anymore. So that's a whole manpower, person power process.
Right.
And go through that whole exercise and then serve them a notice for October to vacate now it's a 15-day notice.
Right.
Of vacate. It's no longer a 3-day, or sometimes the leases are 5 days. but it's a 15-day notice, giving plenty of time to the tenant to come up with the money so that they're not evicted
Right.
from the period of September through January of next year. After January 31st, it's off. All bets are off and we're back to normal, presumably.
Really?
Yeah.
That's interesting. Yeah, that's, I'm not sure how useful that's going to be. I don't know if I see a whole lot changing between now and January, but
Correct.
I hope that I'm wrong. I
Yeah.
hope that we go back to normal in 2021. We'll just sweep 2020 under the rug, maybe pretend it didn't happen, and go back to operating business as usual.
So again, JJ, to get back to your original question, what can you do for the next year? Be very mindful as owners that you're complying with the deadlines in the law, the date deadlines.
Yeah. And that 15-day notice is effectively a 15-day notice to pay 25% of the rent, correct?
No, it's to pay the entire amount of the rent. So it's a 15-day notice.
Payment, then you are giving them 15 days to come up with 100%.
No, it's 15 days of the fact that they must have at least 25% payment, but you're also maintaining your right to proceed should they not.
Okay.
Mhm.
All right. So that's a whole new 15-day notice procedure. Boy, oh boy.
Yep.
Yeah. All right. Well, so we have very, very seriously altered rules for the rest of this crazy mixed up year. And then.
Right. And just for a period of time, it presumably goes back to normal. It goes back to the normal processes under the civil code and under the code of civil procedure effective February 1st. But will it? We don't know. What if they extend it? So,
right. What if they extend it is always the thin end of the wedge, as they call it. It's just the beginning, the camel's nose under the tent. So,
that's right. Yeah.
So just, I know you don't operate a clairvoyant business here, but if you had to think about things that you might see being attractive as permanent changes to our laws and the rules of the road as a result of this, what do you think the legislators would be really, really attracted to making permanent? I'm just curious. Do you have any thoughts about, let's just change the whole way our system works based on this beginning of changing everything for a short period of time?
That's almost impossible to answer. Yesterday, I think I said to you mistakenly that there was a Preston hearing. Actually, it wasn't a Preston hearing, it was Ronan. I don't know if you all remember that there was the buyout legislation.
Right.
The buyout legislation was changed earlier this year to require any settlements of lawsuits with tenants.
Right.
Have a cooling off period outside the court obligation. So in other words, we go to court, I file a lawsuit for non-payment or for some other matter, for nuisance, etc. I end up settling with the tenant and I pay them some money to get out so I don't have to spend all this money to litigate, and it goes 3 months, 4 months, 5 months sitting in court. Supervisor Ronan indicated, well, that triggers the buyout legislation. And if you make a settlement, even if it's in the courtroom scene, you must comply with the buyout legislation. Right. And of course, as attorneys, we're saying, what? How can the judicial branch allow this to happen?
Right.
And that's exactly what the hearing was yesterday. So here we have a supervisor who is the legislative branch, the executive branch, basically saying that you can't resolve any lawsuits in San Francisco County Superior Court. And I'm sure we've all been involved in the settlements, the mandatory settlement conferences on Tuesdays and Wednesdays, out in the hallway, out with the pro tems, making those deals, getting that tenant either to extend and stay on a behavioral stip or out, etc. Can't do that anymore, says Supervisor Ronan. And that was taking away the power of the judiciary. And that was what the hearing yesterday was all about. And we think that we're going to be we're confident that we will win that and it will be thrown out. Even the tenant bar doesn't like that because it's to the benefit of the tenants.
Right.
So looking at that, I don't think that there's going to be an extension unless there is truly legislation from the state that would allow it, with true conversation and discussion about whether to extend the rights of occupants and giving 3-year as opposed to 3-day notices, 15-day notices. I think it's going to be a procedural issue as opposed to a blanket, you may not do things.
Okay.
It will extend timelines more than anything, or extend the timeline from terminating this in February to extending and terminating it in, say, April for this 25% requirement, et cetera. We really don't know. We constantly, as you know, JJ, it's been going on since really March. We do not know. It's constant updating.
Well, and when we first started talking about this, when I first started holding these meetings and calls with our clients, we were talking about, well, do you want to have a secured agreement or a non-secured agreement? And now, I'm glad that we didn't rush out to try to make these agreements with people, because they're all null and void now.
That's right.
And it's basically just the process of having an unsecured agreement and then trying to collect in the small claims court now.
Mm-hmm.
So, once again, I'm sure that you had clients who were eager to make these agreements with people at the very beginning, and in some ways rushing to try to make a decision and to make to put it to bed, so to speak, is actually to your detriment, because you do all this work to try to make it go away and it doesn't.
Mm-hmm. Well, it's interesting, because I think that there are some people who it was fine for a while, and now it just needs to be redone.
Right.
And so it's not necessarily a bad thing that it happened. It's just that if the agreement continues past September 30th, it does need to be redone. It does need to be edited, modified, and a whole different process. Same terms could apply, though.
Right. Well, I want to open it up in case anybody has specific questions about that topic. Feel free to raise your hand in the chat, or raise your hand on the screen, and I'll notice you. In the meantime, I'll also add a couple of things, a few updates that are going on at the city level. If any of you have buildings that were subject to the seismic retrofit ordinance and have not been in compliance with that ordinance, it's important to understand right now the first 3 tiers of seismic retrofit, tier 1, 2, and 3, for pretty much every building except I think the tier 4s are some larger buildings in more specific situations. That was due this year. The rest of them, the Department of Building Inspection is not going to be extending any of the deadlines for those other tiers, but at the same time, they recognize that getting that work done right now under the current conditions with the pandemic is very difficult, made more complicated by the fact that most of our tenants are sheltering in place in the buildings and don't want seismic retrofitting going on at that time. So we are understanding that the Department of Building Inspection they're not comfortable given their current state of affairs with the FBI sitting all over them all the time, with saying something like, we're not going to enforce this law, but the actuality of the situation is they're not going to be enforcing the law. So if anybody didn't do their seismic retrofits, I have a couple of people who've dragged their feet. We are still recommending that they get the work done, because it is to your benefit to make sure your building doesn't fall down in an earthquake. And I'll further add to that piece of advice that if something were to happen and your tenants were severely injured, or that their property was damaged as a result of your failure to comply with the seismic retrofit ordinance, the fact that the Department of Building Inspection wasn't taking enforcement action against you is not a defense. So I am still recommending people do that. It's complicated, and it's made further more complicated by another proposed piece of legislation. Supervisor Stephanie has proposed that construction be halted on all of our buildings as a result of the fact that the construction makes a lot of noise and can have other sorts of disruption, like of water and electrical service, gas service, things like that. But we're hoping to be working collaboratively with the supervisor's office to try to sort of explain that the big issue is communication. Thankfully, we've had no trouble so far that I'm aware of with completing things like unit renovations or seismic retrofitting during the pandemic. And it's because we are doing our best to communicate and to give people realistic timelines and realistic understanding of what the effect is. Most of our tenants are pretty reasonable in understanding that upgrading the building's seismic strength is definitely a benefit to everybody. Let's see there. Oh, the other big piece of legislation that we're working on at the San Francisco Apartment Association is a one-year extension on the fire alarm upgrade legislation that requires us to provide 75 decibels at the pillow, meaning in every room of the house, you have to have a siren that's loud enough to wake people up in every bedroom. That legislation is scheduled to go into effect. All of our buildings are supposed to be compliant with that in July of 2021. The Department of Building Inspection, once again, doesn't necessarily have a system or a procedure in place for enforcement. Their ability to know what's going on is related to the fire alarm companies submitting a piece of paper when they certify the alarm saying whether it's compliant or not. It doesn't involve the building inspectors coming out and actually testing each building. The permits are not, they're over-the-counter permits. They're not permits that involve an inspector coming out to visit. So we're hoping that they'll extend this because that work specifically is going to be, can be very disruptive if you have to expand your alarm system by running wiring and alarms inside of the units, central alarms inside of the units. So we are hoping that that will get an extension so that we can do that after a lot of the work from home starts to die down and people end up going back to work and it's not such a big deal. Susie, did you have a question?
Yeah, for tenants that didn't pay between March and August, is RMC pursuing agreements with them, or is it something that owners need to be involved in?
No, that's something we'll be taking care of. We'll talk to you about your outstanding debts with those tenants, and we will be serving those informational notices. The notice that goes out by the end of September is an informational notice. It just gives their name and everything. It doesn't have any specific accounting information, but it requires the tenant to respond to give a declaration that they are that they have a financial hardship and that their income is less than 130% of the area median income, which is I think in Alameda and Contra Costa County, it's something like $110,000, and in San Francisco, it's $138,000 or something. But they self-declare that their income is low enough to qualify, and that they have had a financial hardship related to loss of income or a job that came because of the pandemic, and that's that. Now, one interesting thing, now that I'm talking about it again, it brings up an interesting point. I had a tenant who was unemployed for 6 months before the pandemic, ran out of benefits in March, right when the pandemic hit. And that tenant can't say that their economic hardship is necessarily directly related to COVID, can he? No. And so I wonder, so what do we do in that circumstance? That tenant still hasn't been able to get a job, still hasn't paid any rent. What do you think, Denise?
I think that if he shows documentation that he's applied at all these places and they can't hire him, et cetera, I think that he's going to say that he has financial hardship due to COVID.
Right. His difficulty finding a job before COVID is not relevant, I suppose, but hard to say he would have gotten a job if it hadn't been for the pandemic. It's easy to make the connection to say that it made it more difficult, but yeah, it's all a matter of being reasonable and being understanding and trying to work it out, because it's a very uncomfortable, very unpleasant situation. Well, that's pretty much everything I've got. Does anybody have additional questions or comments or ideas, thoughts that they want to share? All right. Well, that should get you off on your Wednesday afternoon with a smile on your face, right? It's complicated and it's difficult, and we will just deal with it for the rest of the year and do our best to make sure that we protect all of our clients' rights and take care of the tenants as best as we can. I don't anticipate taking a strongly combative stance toward anybody on this, but we're going to do our best and be reasonable. Bert, did you have a question?
Yeah, just a yes or no. So that means that I can trust real management to handle the manage that my tenant in 59 Kissling if they need to receive any of those kinds of notices or anything like that. I don't need to worry about it.
No, you don't have to worry about it. We're serving all of the notices for our clients. Absolutely.
Okay, that's all I want to know. Thanks.
That is it falls well within the scope of property management work that we are happy to be providing, and we would not, it would be awfully surprising if we said, here, Bert, go send these notices. I
just wanted assurance.
Yeah. Not me.
Okay.
Yeah. All right. Well, thank you very much, everybody. It's good seeing you. Take care. Enjoy the fresh air and the nice weather for once here in the Bay Area, and we'll see you next week. Thank you.
Thank you.
Bye.